human rights instrument ratified by the respondent. Neither they have complied with the constitutive act of the African Union. The respondent concludes by praying that, I quote, the applicants should be denied access to the court and the application should be duly dismissed for having failed to invoke the jurisdiction of the court. In their reply to the respondent's preliminary objection on the jurisdiction of the court, the applicants maintained that the jurisdiction of this court has been invoked, adding that they have, I quote, complied with the rules and protocol of the court in Article 3, Rule 26 and Rule 14. The court overrules the respondent's objection that its jurisdiction has not been invoked simply because the applicants have only cited ongoing cases against them within the national judicial system and have not mentioned the protocol, the charter, or any other relevant human rights instrument ratified by the respondent. The court has held, in previous cases involving the same respondent, that is application 003/2012, Peter Chacha versus United Republic of Tanzania, judgment delivered on 28 March 2014, and in application 001/2013, David Frank Omari versus United Republic of Tanzania, judgment delivered on 28 March 2014, the court held that as long as the rights alleged to have been violated are protected by the Charter or any other human rights instrument ratified by the state concerned, the court will have jurisdiction over the matter. In the instant case, the applicants alleged violations of a number of rights. It is not necessary that specific provisions of the Charter be mentioned in the application. It suffices that the rights allegedly violated are guaranteed by the Charter or any other instrument to which the respondent is party. The court therefore holds that it has jurisdiction, ratione materiae, material jurisdiction, in other words, to deal with the application. I'm now coming to the other kind of jurisdiction, the jurisdiction ratione personae, or personal jurisdiction of the court. The court will now examine the respondent objection that it lacks jurisdiction because the application contains, I quote, allegations against Kenya and Mozambique, state parties which have not made the declaration accepting the competence of the court to receive cases, as per Article 5.3 and 34.6 of the protocol. End of quote. The court notes that in their reply to the respondent's objection, the applicants made it clear that they never intended to involve any other member state in the application, as the application and contention is about inordinate delay in the matters that are facing them in criminal case 2 of 2006 and criminal application 16 of 2006 before the courts of the respondent. This delay having been orchestrated by the respondent, which has made a declaration accepting the jurisdiction of the court. This position of the applicants was reiterated by them during their oral submissions at the public hearings. The court further notes that the applicants are Kenyan nationals. They bring the application against a state party to the protocol, which on 29 March 2010 made the declaration in terms of Article 34, paragraph 6 of the protocol, thus accepting the jurisdiction of this court to receive cases from individuals. The court therefore finds that it has jurisdiction, ratione personae, or personal jurisdiction, to receive the application. Having established that it has jurisdiction to examine the application, the court will now proceed to consider the respondent preliminary objections on the admissibility of the application. Part 8. Admissibility of the application. In its response to the application, the respondent avers that, I quote, "In the alternative, but without prejudice to its preliminary objections on the jurisdiction of the court, it was objecting to the admissibility of the application on 4 grounds, namely, 1, that the application is incompatible with the Charter of the Organization of African Unity or with the Charter, the African Charter, as per Rule 42 of the Rules of Court. 2, that the applicants failed to exhaust local remedies. 3, that the application was not submitted within a reasonable time from the time local remedies were exhausted. 4, that the application does not comply with Rule 34, paragraph 1 of the rules, as it is not signed by the applicants or his representatives." End of quote. The respondent argues in this regard, and again I would quote, that the general maxim is that for an application to be considered admissible, all the conditions for admissibility should be met. The respondent submits that as the conditions of admissibility prescribed in Rule 40 of the rule have not been met, compounded with non-compliance with Rule 34, paragraph 1 of the Rules of Court, this application before the Honorable Court should be deemed inadmissible and dismissed with costs. End of quote. I will start with the first objection. Objection on compliance with Rule 34, paragraph 1 of the Rules of Court. Although this is not an admissibility requirement in terms of Article 56 of the Charter and Rule 40 of the Rules, the respondent cited this as one of the grounds to declare the application inadmissible. Indeed, according to the respondent, the application does not comply with Rule 34(1) of the rules because the application was not signed by the applicants or their representatives as required by the rule. The court finds the respondent objection immaterial and irrelevant, in light of the fact that the main application is supported by the attachments which are signed and referred to in the application. The cover letter from the central prison forwarding the application is duly signed by the officer in charge of the prison. The attachments to the application depicting the evidence of inordinate delay of local remedies and the request for reparation in the application are all marked with the 10 applicants' thumbprints. Both documents are referred to in the main application. The court, therefore, finds the respondent's objection on this point to be baseless and lacking in merit, and hereby dismisses the same. The court will now turn to the other objections on the admissibility of the application raised by the respondent. The court recalls that Rule 40 of its rules provides that pursuant to the provisions of Article 56 of the Charter, applications to the court shall comply, notably, with the following conditions. First, it should comply with the Constitutive Act of the Union and the Charter. It should be filed after exhausting local remedies, if any, unless it is obvious that this procedure is unduly prolonged. And it should be filed within a reasonable time from the date local remedies were exhausted. I will now turn to the examination of these three conditions. We'll start with the compatibility of the application with the constitutive act of the African Union. According to the respondent, the application is not compatible with the constitutive act of the African Union, noting that the application has been brought merely but making reference to cases the applicants are facing before domestic courts. The respondent states further that throughout the application, the applicants have failed to cite any provision of the Charter, the African Charter, that has been violated, noting that the application seeks for the court to deliberate and subsequently adjudicate on matters or actions carried out by the police forces of Kenya and Mozambique, being state parties which have not recognized the jurisdiction of the court by depositing the declaration. The respondent concludes that based on the foregoing, the application has not satisfied the admissibility requirement under Rule 40, paragraph 2 of the rules, and should therefore be dismissed. The court is of the view that the present application is in line with the objectives of the African Union, as it requires the court, as an organ of the African Union, to consider whether or not human rights and people's rights are being protected by the respondent in line with the African Charter and other instruments ratified by the respondent. Therefore, the court rejects the respondent's objection on this ground. I'm turning now to the examination of the second condition, exhaustion of local remedies. The respondent avers that it is premature for the applicants to have instituted this matter before this court, as they have ongoing cases before the national courts which are yet to be finalized. The respondent adds that the applicants have the right to appeal any of the cases against them if they feel aggrieved by the decisions of the courts, but the cases have to come to finality in order for the applicants to exercise their rights to appeal. According to the respondent, the applicants have the additional remedy of instituting a constitutional petition regarding the alleged violations of rights, vide the Basic Rights and Duties Enforcement Act of Tanzania. In their reply to the respondent's argument to failure to exhaust local remedies, the applicants state, I quote, that we, the applicants, in the application, have not exhausted the local remedies as alleged by the respondent. Our complaint in the matter is about the unduly prolonged period that has taken us to be in prison from 2006 up to date. End of quote. The court first notes that the applicants themselves have considered that they have not exhausted local remedies. The question for the court is to determine whether the reasons given by the applicants for not exhausting local remedies fall within the permissible scope of the exception as envisaged under Article 56, paragraph 5 of the Charter. Rule 40, paragraph 5, which is drawn from Article 56, 5 of the Charter, provides that applications to the court shall inter alia, I quote, be filed after exhausting local remedies, if any, unless it is obvious that this procedure is unduly prolonged. End of quote. There is no dispute as to the availability of local remedies, as even the applicants themselves acknowledge that remedies are available, but only that they have been unduly prolonged in their case. Rule 40, paragraph 5, as interpreted by the court, provides a test for the credibility of any local remedy. It does not only require the remedy to be available, but requires it to also be effective and sufficient. In a previous case brought before the court, beneficiaries of the late Norbe Zongo and others versus Burkina Faso, this court indeed ruled that an effective remedy refers to, I quote, that which produces the expected result, and therefore the effectiveness of a remedy as such is measured in terms of its ability to solve the problem raised by the complainant. End of quote. The exception under Rule 40 thus requires that the procedure must not only be prolonged, but must have been done so unduly. This presupposes that resort to the exception will not stand if it is demonstrated by the respondent that the procedure was duly prolonged. Considering the circumstances of this application, the question therefore is whether the procedure has been unduly prolonged. Taking all the factors into account, the court answers the question posed in the affirmative. Since the applicants were arrested and charged before the respondent's court in 2006, until they seized this court in 2013, and to date, almost 10 years since proceedings started, the respondent's court have failed to bring finality to the matter. The respondent's argument that the delay has been occasioned by applications made by the applicants for stay of proceedings cannot stand, as it behoves the courts of the respondent to bring finality to the matter. Besides, there is no indication that the respondent's courts granted any of the applications to stay proceedings in the matter. Furthermore, the respondent's arguments that the applicants should have instituted a constitutional petition or a review is unacceptable, because this court has established that these are extraordinary remedies that the applicants need not resort to, as it was held by this court in its judgment delivered on 20th November 2015 in application 005/2013 in the Alex Thomas versus United Republic of Tanzania matter. Given the applicant's situation, compounded by the delay in providing them with court's records and the absence of legal counsel at the later stage of the proceedings, this court holds that the respondent's objection relating to non-exhaustion of local remedies is unfounded, and hereby dismisses the same. In its response to the application, the respondent submits that the requirement of reasonableness of time has not been met, as the applicants have not exhausted all available local remedies as per Rule 40, paragraph 5 of the rule provides. Therefore, according to the respondent, it cannot be said that the application has been filed within a reasonable time when local remedies were exhausted, as local remedies are yet to be exhausted. The court has already held above that the objection on exhaustion of local remedies is unfounded, as the bone of contention in this application is the alleged undue delay in hearing the applicant's cases. Besides, the court has deduced from the pleadings that the last ruling of the Court of Appeal on this matter was on 20 March 2013, and the application was filed before the African Court on 23rd July 2013. In all estimation, a period of 4 months is a reasonable period of time. The court therefore holds that the application was filed within reasonable time, and thus overrules the respondent's objection on this ground. From the foregoing, the court is satisfied that the application before it meets all the conditions of admissibility under Article 56 of the Charter and Rule 40 of the Rules, and therefore declares the application admissible. Now coming to the merits of the matter, Part 9. I would start with the applicant's submissions on the merits. In the application of 23rd July 2013, the applicants alleged that the respondent has violated their right to own property, their right to freedom, their right to work, and their right to be tried within a reasonable time by the national courts. However, in the subsequent pleadings, that is, in their reply, and during the public hearing, the applicants did not pursue these three allegations.